When this conference was conceived by John Whitty and Nigel Biggar with the support of the MacDonald Foundation, the intention was to have a MacDonald Distinguished Scholar Lecture to begin and one to finish, drawn from either side of the Atlantic. And you'll recall, it seems a long time ago now, on Wednesday evening, when Professor Mary Ann Glendon gave us that marvellous exposition from the United States. It had been our intention to have Lord Justice Laws speak at this point. Sir John Laws, a retired Lord Justice of Appeal, and in retirement, the Goodhart Professor of Public Law at the University of Cambridge. To our regret, he had to withdraw due to ill health. He is still unwell, and I'm sure you'd want to join with me in sending best wishes to him for his recovery. I am delighted, however, that my dear friend Sir Mark Hedley has agreed to take the space in our conference programme, and I know very well he will fill it more than amply with the skills and the experience that he brings to bear. It comes at rather short notice, therefore he's not been in a position to sit in and listen to the debates and discussions which we have had over the last day and a half. And in many ways he's not had the time to prepare anything like the formal paper that he might otherwise have given. But what we will have from Sir Mark is a personal and reflective view based upon his considerable experience as both a barrister and latterly as a practicing judge, giving to us the view from the bench, the judicial vantage point on the issues with which we are currently engaged. Sir Mark was called to the bar by Gray's Inn and practiced largely in Liverpool. He became a circuit judge and was then elevated to the High Court, sitting in the family division, dealing with a variety of cases concerning children, finance, and of course those difficult questions about end-of-life care, whether decisions have to be made by the court. Because he's no longer a serving judge, he was brought in to comment largely because of slightly inaccurate reports recently in the baby Alfie case about the legal intervention in that matter. Sir Mark is an honorary fellow of Liverpool John Moores University. He resides in, and I'm told supports, Everton. And in addition to that, he is a long-term supporter of a youth and community centre within Everton, which exists, among other things, to give free legal advice to those in this deprived inner city area. Sir John Laws, whose late wife was a renowned New Testament scholar, described himself as being a supporter of the Church of England, but one who supports it from the outside, a little like a flying buttress. Sir Mark, I'm glad to say, is the real deal. He is a lay reader. He is a preacher, licensed by the diocese. He is also a diocesan chancellor and transacts business in the ecclesiastical courts. In addition to that, he is the vice president of the Clergy Discipline Tribunal, a tribunal which is particularly active in the current climate of concern for the safeguarding of children and vulnerable adults. I'm in no doubt at all that his personal judicial experience will enrich our conversations, and it's my pleasure to invite Sir Mark Hedley.
Well, thank you, ladies and gentlemen, for your welcome. It's always kind of people to applaud when they've no idea what they're going to get. But thank you for that. It encourages the speaker if it does nothing else. I feel slightly as an outsider in a setup like this, partly because I'm not John Laws, and partly because I went to a school where A-levels were regarded as an unwarranted intrusion on the cricket season. And so that my attempts to get myself into any vaguely respectable university were met by universal failure. So mercifully, the professor of law at Liverpool had a deep contempt for A-levels. Anyone with 3 A's at A-level was, as far as he was concerned, emotionally unstable. And therefore, those who crept in with my unworthy A-levels were welcome, because it looked as though we might be practicing lawyers. So that was. Several years ago in Liverpool, there was a convention of itinerant preachers. And at the end of the convention, their route to the railway station led through the shopping centre. And as 2 of them were going through the shopping centre, they were so overwhelmed by the needs of those around that they decided that they must preach there and then. And one of them mounted a plinth and began to preach. As you would expect in England, not a person paid the slightest bit of attention to anything that they were saying, until a constable in uniform approached him and endeavoured to move him on, at which point a large and interested crowd gathered. Our man certainly was a man for taking his opportunities and engaged in further preaching, whereupon the constable withdrew to appear about 2 or 3 minutes later in an armoured vehicle with 5 fully attired colleagues, and they approached the plinth where this man was still holding forth. He was a man of sound humour and sense. As the police came towards him, he shouted to the crowd, "Behold the first coming forward to be saved." At which point he was arrested and removed from the scene. They did, however, fail to arrest his colleague, a man with a beard of which no Old Testament prophet would have been ashamed, except that it was flame red, and he had a wonderful Welsh baritone. And he got up and carried on, and of course the crowd increased. At this point, another police vehicle appeared with another constable in uniform, who inquired politely of this preacher whether he was not aware that the Queen's Highway was only for passing and repassing upon, and would he kindly move on. Our friend, again, not without some wit, came down and proceeded to carry on his sermon, walking up and down on the pavement. He too was arrested and removed from the scene. And at that point, spiritual calm was restored to the shopping centre in Liverpool. But it was a spiritual calm that did not find expression in the police station, because our 2 friends refused to give their names and addresses and therefore could not be bailed. And like Paul and Silas at Philippi, they sang hymns deep into the night. Finally, they were prevailed upon to give their names and addresses, and they were released and summoned before the magistrates for obstructing the Queen's Highway. And I found myself defending them. It wasn't a very promising defence, it has to be said. I endeavoured to suggest to the magistrate that they could invoke the defence of necessity, having regard to their view of the spiritual state of Liverpool at the time, which attracted merely a sort of quizzical look, saying, "I expect, Mr. Hedley, you've got a better point, haven't you?" Sadly, I didn't have, and they were duly convicted. But young counsel's disappointment at a conviction was mitigated somewhat by the conditional discharge that followed. And for English lawyers will particularly appreciate this, the retrospective grant of legal aid. And now, was the religious freedom of our friends interfered with? Or was this merely part of a reasonable restriction on one particular way of exercising religious freedom? I suppose in this country, the judges, when they are confronted with these issues, tend these days to have recourse first to Article 9 of the European Convention on Human Rights. Because, of course, of all the international conventions, it's part of English domestic law now in a way that the United Nations conventions aren't. And you'll forgive me if I cite Article 9 because it does summarize in some ways the difficulties that we face on a regular basis. So 9.1 says, everyone has the right to freedom of thought, conscience and religion. This right includes freedom to change religion or belief and freedom either alone or in community with others and in public or private to manifest his religion or belief in worship, teaching, practice, and observances. Splendid. But of course, the article doesn't finish there. There is 9.2. Freedom to manifest one's religion or belief shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health, and morals, or for the protection of the rights and freedoms of others. Now, that's a standard qualified article in the European Convention, and the more you look at the qualification, which applies to freedom of speech, personal privacy, and various other rights, you will see that it's capable of being very substantially circumscribed simply by the definition under 2. In practical terms, what the courts have done is to apply a proportionality test between the interference with the freedom concerned and the evil that is avoided or the good that is promoted as a result of that interference. And we have this proportionality test. I could spend a lot of time, which I won't, telling you how it all came about in the first place. And the only reason I know is that the case they chose to do was a case in which I'd been a trial judge and had managed to sort of queer everyone's pitch by finding the facts in a way that they didn't particularly want. But that's the joy of being a trial judge. But Article 9 I cite not only because it's applicable in English law, but it does actually represent, I think, the way in which many judges tend to think and work. And it invites that particular approach which makes judges deeply loathed by the academic community, namely that we postpone principle to pragmatism. And that at the end of the day, judges are there to find solutions that work without necessarily they are being philosophically or even legally pure about it. That is the way things work, and why perhaps there's some justification in an academic conference for having a practicing trial judge's contribution, because there are slight differences in how we do things. My speciality is family law, and I know that all family academics think that the family judges have sold the Children Act down the river in several respects, not the least of which is the failure to take seriously parental responsibility. The problem is I find parental responsibility is not a subject of daily discussion in my local pub, whereas separation of children most certainly is. And you have this endless tension. Anyway, so far as freedom of conscience, freedom of what I believe, we have almost absolute freedom about that. So when Elizabeth I said, "I've no desire to make windows into men's souls," she was saying something that Cromwell repeated and that has basically been part of English thought down the years. But it's not quite as absolute as it seems. What do we do, for example, with a judge who has a religious objection to presiding over a same-sex adoption application? Whose freedoms are actually going to be at stake so far as that is concerned? When I was judge in charge of one particular area of England, family law, we had a judge who was in exactly that position in a relatively small centre. As it happens, he did not wish to make a big fuss about his position over this, and we simply managed to arrange that no such case would ever get anywhere near his list, and the matter was confronted no further, which, of course, is the ultimate bit of judicial pragmatism that upsets academics. But there was another magistrate elsewhere in the country who did want to make a big public do about it and ended up being forced to resign. And you have then this tension being worked out. Is this a proper restriction on a person's conscience for the purposes of protecting the rights and freedoms of others? You know, what is in fact truly going on in Article 9.2? And you get the same problem when you're looking at freedom of speech. We have had several cases in the courts where enthusiastic preachers against the sins of homosexuality have found themselves being prosecuted for hate crime matters and raising the defense, but that's what my religion teaches, that's what I'm therefore entitled to say, and being met with the defense, being met with the answer, well, actually, these people are permitted by our law to live that lifestyle if they choose, and we're going to restrict your freedom so as to protect their rights and freedoms at the same time. And so, again, you're engaging on habitually with this tension between the rights that are set out in Article 9.1 and the qualifications that come with it in Article 9.2. Me just press on and think a little bit about freedom of personal action. You are perfectly entitled in this country, and I have every reason to think it's true in the States as well, to follow your own religious conscience, even if it will lead to your premature death. So if you are a Jehovah's Witness who wishes to resist all blood products, you are perfectly entitled to do so, even though your death will be the inevitable outcome of the choices that you make. That is, of course, subject to two important qualifications. One is, do you have the mental capacity to make that decision? And secondly, are you of an age where you can make that decision? And very often, age is fairly obvious, but the question of mental capacity is often contentious. And we are not allowed to infer lack of capacity from the desire to make a decision of which we deeply disapprove. So we may not use that link. The question is, does a person have capacity to make that decision at the time they make it? And if so, then they're free to make it. And if a person's religious beliefs prevent them from accepting blood products, then they're entitled to do so. I want to come back to the qualifications, though, because they are highly controversial in terms of how the law actually works in practice. But before doing that, it's important, I think, to identify a critical distinction between religion on the one hand and culture on the other. We support freedom of religion. There is no equivalent right in terms of culture, even though we may choose to respect it. And one of the difficulties is that religion is actually quite difficult to define. Those of you who were fans, and I don't know how far this got across the pond, but were fans of a television program called Yes, Prime Minister, may recall an event in which Hacker was called upon to appoint a bishop, or rather to recommend a name to the sovereign for the appointment of a bishop, as the civil servants pointed out to him. And he was offered one candidate, and Bernard said, but he's a modernist. And Hacker said, well, what's a modernist? Said Sir Humphrey, modernism is a theological device which enables a clergyman to continue to draw his stipend even though he no longer believes in God. Now, that is probably a calumny on modernism, but it does just indicate that drawing clear lines of definition in terms of religion is not always easy. I spent a chunk of last year being a member of the government independent review of Sharia councils. And again, we found ourselves having to address what, in terms of the practice of Sharia councils, was truly religion and what was cultural accretion from whichever particular part of the world this particular community came. So the grounds of divorce within Sharia probably are matters of religion. But the procedures by which that divorce is obtained are almost certainly not. And of course, one of the problems was that women were being seriously disadvantaged in terms of their approach to the Sharia councils. And the question was, to what extent is the state entitled to interfere? If it's a matter of freedom of religion, that's one thing. If it's merely a matter of a culture that doesn't sit with the host culture and is causing injustice, that's quite another. And it was important to maintain that distinction so far as we could. Or take a highly controversial issue like the physical punishment of children. Now that has some religious origins to it, of which you will be familiar. You know, those who spare the rod hate their children, but those who love them are diligent to discipline them. Or one later on in Proverbs, which gave great comfort to those of us who went to a good English school. Do not withhold discipline from your children. If you beat them with a rod, they will not die. But the fact of the matter is that there is, as it were, a basis within faith. So that when there are disputes about whether the propriety of this, there is an appeal to religious rights and parental choice in terms of how it works. Now, is in fact what we're talking about a religious right, or is it merely one cultural expression of ways in which children can be brought up, even though it has been adopted since the dawn of time, as far as we know? And again, the answer to that can be quite important. And it's of particular importance amongst new communities in this country who will not see things in the way in which the host culture may agree to do so. The plain fact is, of course, that there is no agreement about an issue like this. Raise it in any company you like, with the possible exception of social workers, and you will divide everybody by age, by race, by religion. It doesn't matter what. People will line up on two different sides of the argument. And really, as far as we've gone in this country, is to say, well, the criminal law puts a limit on the amount of force that can be used, and that's probably the best we can do. Whether that's right or not, others must judge. This distinction between culture and religion is a relatively simple distinction for those of us who are reared in the Protestant tradition of individualism. But if you're reared in the tradition of Islam or Judaism or even Roman Catholicism, then you're reared in a tradition in which culture and religion don't separate quite as easily as they do within Protestant individualism, because the way of life is an integral part of how the religion is understood. And therefore, the distinction is not one that is readily made, but is one that is actually quite important. I want then, if I may, to go back to the issue of religious freedom and legal consents, in particular when consenting on behalf of others. This was something with which I found myself fairly regularly involved in my judicial career, and it tends to be at its clearest, although not exclusively so, in medical matters. I think I'm going to take medical examples simply because they mark out the ground more clearly. Let's start with the issue of circumcision. Now, so far as female circumcision is concerned, there is broadly unanimous agreement in this country that it's not on, and it is prohibited. And it doesn't matter how much you may appeal to religious freedom and religious belief that this is what should happen to your daughter, you are going to be facing a blank wall. And Article 9.2 will always triumph over any rights that you can get together under this. But male circumcision is an altogether much trickier issue. We don't have a general agreement in this country about male circumcision. those of my generation and older, it became relatively normal because in those stages, doctors thought it was healthy. Nowadays, if anything, we have moved the other way, and the general feeling is of discomfort with non-therapeutic invasive procedures, and people don't like it. But to some religious groups, of which Islam and Judaism are the two most obvious examples, it is a fundamental statement about belonging to the community. The evidence that you belong to that community is found, if you're a man, in the fact that you're circumcised. And we remain in the position that where parents agree, then whatever anybody else thinks, circumcision remains lawful. But what happens when parents don't agree? And you meet this most frequently where there's been a cross-religion marriage or partnership which is broken up. And the parents are at war with one another, and circumcision is obviously an issue that is likely to be controversial. What happens then? Well, the way that English judges are required to approach the matter is to judge it in accordance with the child's welfare. Now, of course, the child's welfare may dictate that if he's a Jewish or an Islamic child going to live in a Jewish or Islamic culture, then circumcision is likely to be in accordance with his interests, otherwise you're isolating from the culture in which you think he ought to be living. If he's not going to live in that culture because it was mother who wasn't a member of that community and has gone her own way and the child's gone with her, you might look at the matter rather differently. But it does mean that suddenly we find ourselves confronted with what is a matter of religious conviction as far as parents are concerned, being actually judged on a welfare or best interest test so far as the child himself is concerned. And we're in a slightly tricky area in which there is a conflict between the religious freedoms of the parents and the welfare of the child, not to mention who is making the decision. It is important to remember that religious freedom is very much an adult right. It's not to say children have no rights, but it is the adult who has, as it were, the absolute right. I've mentioned the Jehovah's Witness who wants to refuse to consent to blood products even though he will die. I have to tell you, having tried one or two of these cases, the only issue you're trying is, does the person have capacity to make the decision? And yet, even though that is the only issue you're trying, it is fundamentally a difficult one to try, because you know perfectly well that if you find in his favour, someone will ring you the next day to say you may be interested to know that Mr. So-and-so died in the early hours of this morning. And you only have to have that phone call once or twice, and trying to keep the distinction between what is truly capacity and what is merely unwise decisions is actually an extremely difficult one to maintain. But if you are under 18, then you don't have the right to consent in quite these, or refuse consent in quite these circumstances. It is always subject to a best interest test. So, for example, when you get Jehovah's Witness youngsters who wish to refuse blood products, are completely supported by their parents in that refusal, it is subject to a best interest test. And you will not perhaps be surprised to hear that almost invariably their refusals are overruled by the court on best interest grounds, notwithstanding the unanimous, as it were, religious assertions advanced on behalf of the child and his parents. And you get a similar problem with adults who lack capacity. Let me give you an example. A Jehovah's Witness family, married couple, 4 young children. The mother is struck down with so serious an insult to her liver that she requires an immediate transplant if she is to live. This is on a Saturday. She is unconscious, so she doesn't have capacity to make decisions. Her husband, who is the next of kin, is refusing to consent. And so a court hearing is required. And it's set up in such a way that counsel are in their chambers and everybody else is in the hospital, and it's all linked up to the judge's mobile phone, which is mine. And it's the only trial I've ever conducted sitting in the front of my wife's car, parked outside Chester Zoo on a Saturday afternoon, deciding this particular issue. And at the end of it, I having overruled the objections and authorized the treatment, my wife made the interesting comment that she'd never heard a man who was giving evidence saying one thing, who so manifestly wanted the opposite. And those are the tensions that are around there. So he didn't get what he asked for, but he did get what he wanted. And again, if you want purist arguments, you can say I'm wrong. But we don't live in that kind of world where the purist argument can always succeed. Can I just turn with you a little bit to the question of the withholding or withdrawal of medical treatment from babies where it is opposed on religious grounds, which actually, in most cases, it is, as it happens, most of the ones that actually get to court. We've had two very high-profile cases recently. I don't intend to say anything about those because I have deliberately not read the judgments in either of them, so that when television interviewers wanted to ask me questions about the cases, I couldn't answer them. I could only talk about the general principles, which is what I was supposed to be doing. So I haven't read them deliberately. But I want to take, if I may, three from my own court, which I think perhaps make the points in much the same way. The first was in 2004. It went viral across the world. My son was working as a doctor in Australia and sent me an email saying, "What are you doing? You're all over our newspapers." And just occasionally, these cases do that. There was a case of Christian parents opposing the withdrawal of treatment, the withholding of serious intervention treatment in that case, basically on the grounds of hope springs eternal, and basically on the grounds that it wasn't for anyone other than the good Lord to decide when the right time had come for that life to come to an end. The second case was one with Christian parents, 5 children, not a word to be said against them as parents. Their third child needed a kidney transplant because she was in a difficult position. And the parents objected on the grounds that the good Lord had promised to heal this child and that to consent to medical treatment would be a statement of lack of faith in the promise they'd been given. And, just to make it a little bit more difficult, there was an attested account within the family history of a child who'd been given up as dead at birth, actually wasn't dead. So there was... I have to say that the doctors who were dealing with the case, I don't think began to understand what the parents were saying or believing. It so happened that I was in the happy position of understanding it rather more. And then the third case was a child who'd suffered a catastrophic accident at home with Islamic parents. The doctors had decided death was inevitable, all treatment was futile. They wished to withdraw the lot, which would result in a very early death. And the parents were simply saying, although Islam does permit us to consent in some circumstances, it doesn't include these circumstances. If we have a child who is hopelessly and irretrievably damaged, our religion requires us to look after this child for as long as God gives it life. Strangely enough, you could have consented to treatment if they couldn't have afforded to pay for it. But that's just one of those sort of odd things that you have to deal with from time to time. But so those were the cases. Now, in all three cases, I found myself in disagreement with the parents and in applying best interest tests to overcome their religiously based objections. In the first and last case, what I was actually doing was saying this child is going to die, and part of my task is to make sure that this child has a good death. Actually, it's very difficult to say what a good death is for a child, but it's very easy to say what a bad death is, namely wired up to machinery isolated from all human contact in the course of futile treatment. If a child's going to die, let it die in the arms of its parents and nowhere else, was broadly the line that I took. As it happened, both sets of parents were willing to accept that decision in the end. But the other one, where they had been promised healing, I found altogether far more difficult. And in the end, I overruled them simply because of the insistent, unanimous view of the medics that we had to get on and do something. And I kind of found myself saying, I hope, not irreverently, that if the good Lord does not like my decision, he has time to act before the doctors do. And I think one almost, as it were, had to leave it there. And you can take another view. Part of the question about all this, in terms of religious freedoms, is who actually is to be given the final say? The reality within the English system at the moment is that the judge has the final say based on the best interest test. There is quite a body of view building up after the two most recent cases that the parents should have had the final say in the circumstances. That is what our law once said. Parents did have the final say in these matters, and courts stayed out of them. It is vividly illustrated in the affairs of Mr. and Mrs. Agar Ellis, whose disputes occupied the Chancery Division for some 5 years at the end of the 1870s. Mr. and Mrs. Agar Ellis, one was Church of England and one was Roman Catholic, married. The mother was Roman Catholic, and they agreed that the children would be brought up Roman Catholics. There were 4 girls. They were all brought up as Roman Catholics. The parents separated and went their separate ways, and the girls went with the mother. After a while, the father took the view that these girls were being indoctrinated, and he did not want them indoctrinated, and so he removed them from the mother, and because, of course, it would be beyond his capacity to look after them, they were placed with good Church of England governesses for the purposes of ensuring a proper religious education and upbringing. When the oldest girl reached 16, she inquired whether she might now be permitted to see her mother, which was refused because she wouldn't give a promise not promptly to go with her to Mass. The court's view was this was a matter entirely for parents. And since in those days, if the parents disagreed, the father had the final word, that was the end of it. Please don't waste our time, go away. Now, we have to ask ourselves, if you translate that into a setting now about consent over medical treatment, consent to life, and all the rest of it, is that where we want to be as a society? To which the answer may be yes or no, but Mr. and Mrs. Agar Ellis kind of illustrate where we can end up if the state abandons all responsibility for decisions of that nature. And of course, I ought just to mention in passing, you can occasionally even get disputes between religions themselves. Mark kindly mentioned that I was a chancellor. One of the early applications I had was from a Chinese family wanting to exhume Granny's remains and transport them from Merseyside to London so that ancestral worship rites could more conveniently be practiced. I refused on the basis that since they'd chosen a Christian burial, they were stuck with Christian rules, and we weren't going to allow a body to be moved in those circumstances. But you get these sort of debates going on as to where we go and how. So, where are we? Where should we go? Let me bring this to an end, if I may. I hope I've said enough to demonstrate that freedom of religion is not quite as simple as at first it may seem. Like all freedoms, They are easy to articulate and extremely difficult when they conflict with one another. So that freedom of religion, I can identify what your freedoms are. The problem is when they conflict with other people's freedoms and rights, how do we deal with it? And the English system is profoundly pragmatic in that. There is, I think, a much readier, much greater readiness in the country to dispute religious freedoms and the right that they should have. There will be a strong party which will say, we don't mind what Judaism and Islam teaches about circumcision. It isn't good for children, so it shouldn't be allowed. And there is a body of thought building up about that, which will come to a head in due course, I dare say. Or there are disputes about, well, that's not religious freedom at all, that's culture. And I've mentioned the Sharia councils and the question of children as an example of how that is. And my own estimate is that the more pluralistic and the more secular our society becomes, the more we will see these challenges being brought into focus and be driven to try to find principled ways, if we can, about how they're to be resolved. We kind of have a strange tension between the need robustly to uphold freedoms, however much they challenge the conventions of our society, and yet at the same time, the need to be aware of cultural norms. I was brought up in 1950s England. It is a society which is simply utterly unrecognizable from England in 2018. And I occasionally, as a test, think, well, what would a judge of the family courts, or probate, divorce and admiralty, as he would then have been, came and sat with me in a family court today? He would not only be astonished at the range of work and at the powers we have, but at the complexity of the tasks he would have to undertake. If you asked him what his job was, he says, I find the facts and then I apply the agreed norms of society to those facts, and lo and behold, I've got the answer. To suggest that you could do that in modern British society, or probably modern American society, is simply make-believe land. You can't do that. Those kind of shared values simply do not exist. So we need to recognize that society probably needs constraints. Of course we need tolerance. Of course we need respect for religious belief, particularly where the beliefs are those from which we differ or even profoundly disagree. But there is a real challenge in holding a balance between that and between the other conflicting issues that we've been looking at. It is one thing to talk about a society that's democratic, because of course that involves the prevalence of the wills of the majority, and a society that is free, which does not allow the majority to exercise predominance in quite the same way over the minorities. And my guess is that that tension between living in a society that is democratic and living in a society that is free is going to become the more acute the less we have communal values, the less we have any agreed norms from which we can work. And my guess is, as I look at our society, as we become more pluralist and become more secular, so we will shed more and more of these common values. I'm going to stop there, and if anyone wants to reflect or comment, they'd be very welcome to do so.
There is time for questions. I must say, to adopt a footballing analogy or soccer for our American visitors, it feels a little bit like the substitute who comes from the dugout in the closing minutes of the second half, scores a spectacular winning goal, and is then carried shoulder high from the stadium. So, Sir Mark, thank you very much. A question here in the front row.
Thank you very much for a very interesting talk. A question on the intersection maybe of philosophy and law, I think. What is the legal justification, or maybe philosophical justification, for proceeding on the assumption that a High Court judge however highly obviously qualified, intelligent, and so on and so forth, is actually in better epistemic position and moral position to make the decisions in the best interest of the child, given that the judge in question prior to the case has probably never met the child or even heard about the child, and given that after the case, the judge will not really have to deal with the practical implications of his judgment.
I think completely fair point. I think I say to parents when I'm dealing with disputing parents, I said, you know this child better than I do. You know what's right for this child better than I do. My decision will be less good than yours, but if you can't sort it out for yourselves, then you're stuck with a less good decision. And that's the way it works. So the justification is that every society has to have the means whereby disputes between citizens and disputes between citizens and the state are authoritatively resolved. And we've tended to use judges to do that. And one of the things you learn as a judge quite early on is that you are endlessly, whatever jurisdiction you're in, you're often making decisions about things which you know you are less expert in than the people sitting in the courtroom. And you're doing it simply because there has to be an authoritative resolution to the dispute. So, I'm knighted and called my lord in court, not because I like it, well, perhaps I do, but that's not the reason. It's because I am charged with giving an authoritative and binding resolution to the dispute. And I actually think that is the only justification that works at the end of the day, because I think what you're saying is entirely correct, and the only answer to it is this is a social device for resolving disputes, and we use judges where everyone's had a fair hearing and all the rest of it.
I think that's really... Can I let Ryan come in, because we're short on time for questions.
So, Mark, thank you for such an enjoyable and honest presentation there. I'd be interested in your view on potential reform to the law with regard to end-of-life situations for parents and the threshold in which the state can, if you like, take those decisions. Those that are kind of discussing reform are talking about a potential shift in the threshold at which the state can interfere and raising that threshold, in fact, from best interest to significant harm, which of course already exists in the Children's Act in the context of social services wanting to take a child out of the care of its parents. Do you think there would be undue harm to children in these situations if the threshold was significant harm rather than best interest?
Okay, thank you. At the moment, there is no threshold. It is a simple best interest test, which is not a threshold because it's a value judgment, not a factual one. And the appellate courts have consistently refused to define best interest. Parliament won't define best interest. No one will define it. So there isn't a threshold. Now, if you introduce a threshold of significant harm, I'm not persuaded that it's going to make an immediate impact because you're going to have to say likelihood of significant harm, aren't you? That's the test you're going to use if you're going to use the care test for the intervention of the state. And you are almost, by definition, dealing with cases in which the child is suffering significant harm. So I'm not quite sure where it's going to take us. So if you say, well, why weren't those parents allowed to take their child home, for example, or to take the child to Italy? I don't know the answer to that because, as I say, I deliberately didn't read it. But my strong suspicion from other cases I've done is there was very strong medical evidence that the child would never have survived the transition. And that's why it was objected to. That would be that answer would be justified on your threshold or no threshold. So I'm not at the moment. I would need to understand cases where it would actually make a difference. And I'm not sure, in my experience of what we are actually asked to decide, that applies. Because for the most part, we don't want to touch these cases if there's the faintest chance of any common ground between parents and medics, which of course almost invariably there is.
Ian Lee.
Yes, just a question about how courts should deal or do deal with questions where it's actually disputed what the religious requirements or doctrine involved might be. The obvious answer might seem to be that you hear expert evidence, but then you have to choose. At the end of the day, how is that done? Is it just for a judge to do that?
Yes. I hesitate because I find it quite difficult to work out exactly what the fact-finding process is isolated from the specific facts of a case. Because when you have a contest between experts, sometimes it's clear one expert is more expert than the other. Sometimes it's clear that one expert actually got a better grasp on the specific facts of this case than another one has. And so your choice about where to go is governed very much by those kind of fact-sensitive decisions to that particular case. The plain fact is, to the grief of much of the academic community, English law in practice tends to develop on a case-by-case basis and is resolved on a case-by-case basis, which avoids us having to answer just the sort of questions you've raised. But it's almost because they can't be answered. I actually don't know what the answer to your question is generally. I could answer it in the context of a particular case. I could give you an explanation of why I prefer one expert to the other. Whether it always has to be done by experts, I'm never quite sure. The difficulty is, shall we say, if we take Sharia law, for example, which is something that we will encounter on a regular basis, and even if you can extricate the cultural accretions from it and get left with the essence of Sharia law, you've still got 5 juridical schools. And the question is, who are you going to prefer? Well, you're going to start by saying, well, which juridical school do the parties belong to? And if they both belong to the same one, which in this country they usually will, that solves that particular problem. If they don't, of course, you've then got insoluble problems. And I found myself more than once saying to a solid Muslim setting court, do you really want an outsider to resolve this issue? And of course they all do, because they've given up trying to do it themselves. And I think it is very difficult to give a principled, clear, consistent answer to how we do it, I'm afraid.
Any final question on this rare opportunity to cross-examine a High Court judge? John?
Sir Mark, thank you very much. I wondered about how you make those gut-wrenching decisions, the ones that really try your conscience. When you're sitting making a decision about life and limb, about life and death. Obviously you're following your judicial wisdom and long experience. Obviously you're following precedent. Obviously you're guided by legislation. But in the end, what drives your decision?
Well, that's a good question. And the answer is that there are virtually no precedents in these cases because they're all fact sensitive. There's virtually no legislation other than best interests. And all you've got is how do you sort that out in that particular case. I know people within my own Christian community say, well, now, do you pray to see the answer? And actually I say, no, I actually don't trouble the good Lord about that because he is not to blame if I get it wrong. It's only me that's responsible for this. So I may generally pray that I'm, wise and thoughtful and listen to people and do the basic things that judges ought to do. But in terms of actual decisions, I take that as my personal responsibility, in which nobody is going to dictate an answer to me, however, from wherever. Now, I think there is an element of gut about this. There really is. So, for example, most of us who've overruled youngsters who want to do things that are going to damage them, will say we will give all sorts of good principled reasons why we've done it. But there will also be a recognition, I actually want to sleep tonight as well. So, you have to recognize there's a strong human element that works into this. And so with some of these decisions, and I think at the end of the day, there is a certain amount of gut choice about this. So I said, I want children to have a good death. I doubt any of my colleagues would put it that way. They would find other ways of expressing what we'd probably reach the same result, but they would find other ways of expressing it. And I think that just models the sort of strong individual responsibility that is given to a judge at that moment, because what people need above all is a decision. Everybody is hopelessly and utterly stuck and going nowhere. Somebody has got to make a decision. And so the first thing you owe to them is a decision. If you say to them, I'm sorry, it's all much too difficult, I want to go away and think about it and have another 14 expert witnesses and all that, you are doing no one any favours. That's not what is going on. So there is an element of gut feeling about it, and you kind of are trusting to your own experienced judgment about what is right for this child without, if a philosophy for life doesn't have a place for death in it, well, there's something wrong with the philosophy of life. Death is perhaps one of two things, in addition to income tax, that comes to all of us. As one of, was it Benjamin Franklin? Yeah. So I think that there is quite a lot of instinctive. I'm actually a great believer in trusting instincts. I think we ought to work to hone good judicial instincts, because they're crucial often in dealing with just this kind of case, or indeed, which witness am I going to believe? It's not always easy to do it rationally. There is more to it than that.
I know we're about to move seamlessly into a closing panel discussion. But before we do that, I know, Sir Mark, you were up at the crack of dawn to make the journey here from Liverpool. And I think it's hugely fitting that in a conference which has embraced high-voltage theory, we conclude with very practical, real and earthly issues where the rubber hits the road and where somebody has to make these important decisions within the context of the law, but applying religious beliefs. Mark, my lord, we are hugely in your debt. Thank you very much.